respected Director, Center of Innovation and Consultation, Prof. IR Dr. Sri Mala, Honorable Speaker, Mr. Mohd Radhi Ahmad, Head of MyIPO Northern Branch, and all fellow audience. Okay, thank you so much for joining us in our Coffee with CIC this session in the morning. Okay, I think many of us keen to know more on how to protect our invention. Thus, this is a good opportunity. We bring to you our expert, a big name in this area. Again, thank you so much, Mr. Radhi, for having a session with us. We know that you're having a very tight schedule. Thank you again from CIC. Okay, before we start, I would like to invite our Director of CIC, Prof. IR Dr. Sri Mala, to give a welcoming speech. Okay, Prof, the floor is yours.
Okay, thank you very much, Dr. Muaz. Sorry lah, bising sikit latar belakangnya. We are at the Myra audit today, Mr. Radhi. So first of all, I would like to thank Mr. Radhi to be with us. Terima kasih banyak-banyaklah. So for the participants, terima kasih juga kerana meluangkan masa untuk bersama dengan Mr. Radhi hari ini. He is the head of MyIPO Northern Branch. And beliau bersama kita hari ini untuk share the important requirements for patent filing. Sebenarnya ini adalah macam mukadimah lah, just perkenalan mengenai patent filing. Tapi selepas ni kita akan ada satu khusus untuk akan berlanjutan untuk beberapa hari untuk kita draft patent, how like we do for publication. Now we want to teach the researcher how to write a patent. Okay, there are certain jargons that you need to use. There are certain pattern of writing it, what are the patent search that you need to be done and things like that. So please take note. This 2.5 years, 2.5 hours is very important for you to understand the fundamental requirement that must be there in order for you to draft a patent later. Yeah. So please take opportunity. Kalau ada soalan, tak faham apa-apa, please you can put in the chat box or tanya Mr. Radhi. Boleh Mr. Radhi? Mereka boleh interrupt if they don't understand. So with that, I would like to thank lah Mr. Radhi kerana dalam kesibukan pun beliau bersama kita untuk membantu supaya pencara-pencara faham all the requirement for patent filing, and it's very important. Saya tahu USM suka file copyright, Mr. Radhi. Banyak copyright kita ada, tapi kita nak improve bahagian patent lah. So I hope you can give more focus on the patent because it's very important for product commercialization to have patent filed. Yeah. So with that, I don't want to waste much time, and I would like to also to thank the CIC team for organizing this event, terutamanya Miss Atini lah yang bersungguh-sungguh telah buat semua arrangement for this particular talk, and also to rest of the CIC team lah. Thank you very much. So with that, I pass the floor to you, Dr. Muaz.
Okay, thank you, Prof. Simala. Okay, then come to our main agenda. Okay, before that, let me begin with introduction of Mr. Radhi, tremendous background lah. Okay, so far Mr. Radhi started in year 2003 as a patent examiner in Intellectual Property Corporation. Then he served about 10 years and being promoted as senior patent examiner in 2013. And at the same time, he acted as a researcher under WIPO Fund in Trust in Japan Patent Office Tokyo. And at the same year, he did an intern at Shiga International Patent Office in Tokyo. Then since 2015 until now, he is the Director of Northern Zone Office at Intellectual Property Corporation in Malaysia. So boleh dikatakan kita bersembang dengan orang yang top gun in MyIPO. So thank you so much to be with us, Mr. Radhi. Okay, Mr. Radhi, saya rasa kita boleh bermula. The floor is yours, Mr. Radhi. Thank you.
Okay, terima kasih, Tuan Musi. Saya share.
Okay, boleh share.
Tidak sharing ke atau masih?
Cik Radhi, kita nampak macam masih dalam belum presentation mode. Okay, kena tekan. Okay.
Okay. Oh, okay.
Okay, cantik. Okay.
Okay, Assalamualaikum dan morning to all. Okay, first of all, terima kasihlah kepada CIC. Saya campur-campur English PM.
Tak ada salah.
Ya, memang in patterns memang preferably slides to be in English. Banyak term legal dalam English, term pattern pun banyaklah English lah. Bila kita cuba translate tu, direct translation memang out dia punya meaning lah. Tapi insyaAllah lah kita boleh, saya akan cuba explain. Terima kasih kepada CIC USM kerana menjemput MyIPO untuk berkongsi sedikit maklumat lah berkenaan requirements of patent filing untuk hari ini. Topik kecil, a small topic in patent. Kalau cerita patent memang lebih luas lah. Patent is part of IP, like Prof. Srimala mentioned before. USM prefer copyrights, but to be clear, copyrights tak protect inventions. Just a brief introduction lah. Patent yang protect inventions. That's why kat MyIPO pun we encourage innovators or researchers to file for a patent. However, we know that there's some halangan ataupun difficulties lah yang dihadapi oleh universiti, especially the cost. If you engage a patent agent, memang cost agak tinggi. That's why dengan perkongsian hari ini diharap researcher yang terlibat dapat mendalamilah kalau ada berminat untuk menyediakan sendiri dokumen untuk patent filing sini, because you can save a lot. 70-80% of the cost you can save. Okay. Oops, sorry. Okay. A little bit about patent, introduction to patent. What is patent? It's an exclusive right for an invention. That's why, like I mentioned before, patents protect the invention, not copyright. Copyright protects what you write about the invention, your research report, your journal, and so on. Writings, video, music, that's all under copyright. But for invention, only under patent. Whether it's a product or process, a new way of doing something, or offer new technical solution to a problem. It's a right granted by the government to the inventor that is stipulated under Patent Act 1983 or Act 291. It's kind of a small, undang-undang baru lah. Kalau dalam patent dokumen tu, there's one part very important, it's called patent claims. Patent claim is kind of new law that will protect your invention for a limited time, basically about 20 years. Okay. Oops. Okay. Okay, when the government give you a right in
Cik Radhi, kemungkinan slideshow hilang rasanya di screen.
hilang ke? Sekejap saya.
Kena share.
Adakah?
Setakat ni di paparan saya tak ada slide hilang.
Okay, sekejap tadi tekan space. Saya
Okay, keluar balik.
Tapi tak resume slideshow. Okay, keluar dah slideshow?
Okay, keluar. Cantik.
Okay. In exchange, bila the government give you the rights, in exchange, government, the inventor must disclose the technology, make it available for public inspection. In this case, in Malaysia, public inspection, but in other countries, sometimes they publish the paper, full paper, full patent specification. But in Malaysia, only the abstract. because it's limited by the law lah, our local law. I'm not sure why we define kita masih limit kepada certain abstract saja, but in apa nama negara maju, advanced countries more than total disclosure. Same with the research, bila you publish the journal and so on, you want to disclose the research findings to the academic community, but in patent it's kind of similar. You want to publish the outcome, the result of the invention. In return, you get the patent rights, the rights to the invention. That's why the patent must include detailed description of how to use, how to make the invention. Okay. Under patent system, the patent owner will get 20 years rights to exclude others. What is meant by exclude others? Everybody else cannot make the same invention that has been mentioned in the patent claims. You get the rights. You disclose the invention and you get the rights to exclude others from using the technology, whatever the subject matter about in the patent documents. And in the IPO, Intellectual Property Office, the technology will be disclosed to spread new knowledge and so on, similar to what has been done before in publication papers. Same thing happened with patent documents, so that the patent will be cited by others can see and further make a new improvement to the invention in the future. No redundancy, no overlap invention have been made. That's the intention, so that the government give the rights and the owner will disclose the invention. Okay, why you apply for patent? Like mentioned before, the exclusive rights and commercially to stop others from commercially exploiting the patent invention. They cannot commercially make, use, distribute, imported or sold by others without the patent owner consent. When others want to use the technology, they need to get the consent. And of course, there's some sort of agreement like licensing or assignment that you sell the patent, or you can just give it for free, up to you. It's your own, it's your property. That's why we call it intellectual property. It seems kind of similar to other property. It can be sell, license, kind of rent. The license is kind of renting system without the patent owner's consent. This has been happened before in Penang. There's a company importing an insulated container from China. However, there's another patent owner in Malaysia. Although the patent owner does not file the patent in China, but it filed the patent in Malaysia, the company that imported the container has been warned by the patent owner, because the patent owner is using the patent owner's invention in the market. And later on, they settle that the patent owner need to buy the container from the patent owner in Malaysia and stop importing from China. That's why they protect the invention and enforce the rights in Malaysia. Patent is territorial. Almost all intellectual property is territorial, meaning that the patent, the protection only in where the country is being filed, where you file the patent. If you file in Malaysia, it's protection only in Malaysia. If you file in US, only in US. It's not international patent. There's no such thing as international patent. However, the copyright is internationally protected, but the protection is limited, not protected. It's not protecting your invention. Okay. Your patent rights is not absolute. If you don't pay the maintenance fee or renewal fee every year annually, the rights can be lost. Another thing can happen if the if another party file a case to try to invalidate your patent. They provide some evidence showing that the invention is not novel, there's a prior use, prior disclosure before that the patent examiner might not found, and it can be invalidated in the court. However, this kind of case is very rare but do happen sometimes because patent office will try to process or to do an thorough examination as best as possible to ensure that the patent rights cannot be challenged in the court. Okay, steps before filing a patent. First, you need to determine whether the invention is patentable or not. Is it under patent or is it under copyright? If the invention or the research is basically about academic purpose only, there's no technical involved, maybe it falls under copyright. Another thing you need to check with Patent Act Section 13 in non-patentable invention. I will explain later on about non-patentable inventions, but I'm sure most of the invention or research done by the universities are patentable because it involves some technical background, technical steps, and so on. It can be patentable. The second step is the most important thing, prior search and analysis. Usually, I think perhaps the university engage the patent agent to conduct the patent prior search analysis. However, if you can do this by yourself, it can save a lot, and also can be it should be done before you proceed with your research. Sebelum research tu, after the maybe you get the title of research, the Hala 7 research, and then before that you proceed further, you conduct prior search. I think you also did the same in the research. I think literature review, something like that, the bibliography, you try to search for prior publication papers, something like that. Similar, but if you intend to patent the document, you search for patent documents related to the invention to know that until which steps have been done, has been patented, because in patent, about 80% are not produced. They do not produce the product. It's just stop until the idea concept. Because patent is protecting the idea, it's not protecting the product. If you have an idea that seems plausible, can be done, you have not created a prototype yet, you just file a patent for it. And lastly, you draft a patent specification. It's a requirement for patent filing. You need to prepare a complete patent specs according to the proper format. The content is basically the same as a research report. So if you already complete the research report, you can just take the content and rearrange according to the proper format of patent specifications later on. Okay, steps before filing a patent. Like I mentioned before, after the idea creation, you conduct the prior search. We call it novelty search to make sure that the idea for your research is novel. This is a best effort novelty search. It's not really thorough, but it's just enough to show that a search has been done and there's no immediate prior art has been found. Okay, after that, maybe some R&D to prove a concept, marketability research if needed, and you prepare the documents for patent filing, patent drafting, and then patent filings. Preparing the patent document can be a little bit tricky. Not that it's difficult. Everything first time always difficult, but after a few times you do it, it can become much easier. Either you do it yourself or using the patent agent. If you do it yourself, it's crucial to know that the proper format of preparing the documents, so that although the subject matter might be novel, but sometimes the patent application is objected, or we call it adverse report for improper formality requirement, such as the proper format for the documents. Okay, why patent novelty search is important? This is an actual case I want to share with you. There's an invention in, I think, about 2017 or 2018, a machine for climbing palm oil tree. The machine can be controlled by a user or pre-programmed. It has a cutting blade to trim the palm oil tree or harvesting the fruit. However, there's a prior art in 2012 published in US about palm tree trimming. The inventor of this invention is very confident that there's no such invention in the world before, because basically only in tropical area that has been been planted with palm oil tree, maybe in Indonesia, but a researcher from local university is very confident and try to proceed for a patent. After conducting a prior search, a similar product, similar invention has been found in US. Although US do not have a palm oil tree, they do have palm trees for decoration, especially in warm area like Florida, something like that. There's a machine for trimming the palm tree there. The subject matter, or we call it technical features, is exactly the same. At first it's very 100% the same. However, the inventor is advised to make a comparison to come up with something new, so that it can be differentiated. For example, maybe the grappling mechanism, the climbing mechanism, or the cutting actuator, something like that, is different from the prior art. The basic concept is the same, but maybe in the details they can be differentiated, and later on maybe the document can be prepared differently and go for a patent. And the invention will become quite narrow. It's not. At first, the inventor tried to make it as broad as possible. In case that something similar has been created, he can take actions against the infringer. However, in this case, he will become the infringer. But if he sells in US, if the US do file in Malaysia, the patent owner can take action against him if he commercialize the patent. Okay. In case you want to use a patent agent, this roughly the fees involved about 10,000, maybe less, a little bit, maybe more, usually more, especially involve the complicated technology such as pharmaceutical, biotech, and software. The normal, or we call it the traditional technology like electronic, mechanical, roughly about this price. There's if you see at the quotation, the first step is novelty search, costs about 1,000. Around that, maybe more. If you can do it yourself, it will be much, you save a lot, you save much more. And the second step is the most difficult thing to do, the drafting of patent specification. Why they charge a lot? Because they need to learn the technology. They need to get the info from the inventor. They maybe give the inventors a set of questions about the subject matter of the invention, and then from there they try to write the patent spec based on the information. Sometimes not all information has been given to the patent agent because the question is not right, but the inventor respond or the researcher respond based on the questions. If the researcher can write by themselves the patent spec, maybe the patent specification will be more complete, more detailed, so that it will be comprehensive and cover a lot more. Okay, what's the official fee for MyIPO? Yeah, about 1,500 only. This is the complete fees till you get the patent granted. If the no objection, actually if there's any objection, we don't charge for the objection. Because there's no fees for answering the objection. Okay, is there any question?
Yes, Encik Radhi, kita ada satu soalan. Berkisarkan tadi ada example yang Encik Radhi maklumkan. Okay, from Dr. Chua Yun Shen in chat box. Dia kata, back to the example that you just gave just now on climbing saw. Can the researcher still file the patent in Malaysia if the US inventor didn't file in Malaysia?
You can file, but not 100% the same. Must be some improvement in because it's not novel. It must be new in the world. Cannot be 100% the same lah. You need to add on some features to make it different from the US publication or any other prior art form. That's why it's important to conduct prior art search to determine that the level of novelty. The novelty is not like if there anything similar, it's not considered novel. There must be some sort of for example, the prior art explained 5 features. You invented 7 features. That's different the features and things. But when you claim the invention, you claim all 7, not just the extra 2. So it can still be patented in Malaysia, but make sure it's different from the prior art. That's why when you, later on I will show you the prior art search and analysis example. When you conduct the search, you create a table, analysis table, to identify the same features and the different features. When there's a lot of different features, there's a possibility of novelty invention there. Okay.
Encik Radhi, kita ada satu lagi soalan Encik Radhi, ataupun kita nak kumpul dulu di bahagian belakang, later on Encik Radhi counter semua, ataupun nak
okay. Kalau question tu related dengan slide, saya boleh jawab terus lah. Kalau tak lagi later on lah. Okay. Boleh.
This question dia bertanya pasal utility patent versus normal patent. Need to know the best option.
Okay, boleh, tak apa, no problem saja. Utility patent atau di Malaysia we call it utility innovation.
Yeah.
Basically dia sama patent patent is basically under the same law. Cuma different dia utility innovation, only one claim is allowed. In patents, there's more than one, maybe 10, 20 claims, no problem. Another thing is in UI only, we call it UI, utility innovation, only novelty requirements, no inventive step. Nanti saya akan explain tentang ni, novelty dengan inventive step. Basically, kalau benda tu baru saja, novelty dah satisfy, it can be granted lah, dapat sijil on that. But inventive step ni macam obviousness lah, nanti dia macam combination of 2 invention to come up with the same filing, patent filing, is not satisfy the inventive concept lah. Okay, suara clear kan? Tadi ada tak clear?
Ada kadang-kala suara Cik Radhi sedikit
tak apa clear, saya nak ni
bergegar sikit tadi.
Okay. Saya rasa clear.
Okay, so far alhamdulillah clear.
Okay, saya guna ni lah, mic ni untuk clear sikit. Okay, next. Okay, patent spec versus research report. Macam saya kata tadi, basically sama saja content. Patent spec ni pun maybe evolve from ni lah, patent research report. cuma nama dia lain sikit. Basically the content dia sama, title, research, technical field, maybe research field, background art, literature review, research background, summary, introduction. Cuma satu saja ada bahagian yang tak sama, is the claim lah, patent claims. This is where the legal aspect masuk. Sebab patent spec ni dia ada masuk legal element sikit. Di bahagian claims is a combination of legal plus technical. Jadi di sini the legal is not much, it's just the format. The content is all technical, but the write up is kind of legal. I show example later on. That's why macam saya kata tadi, kalau dah ada research report untuk menulis patent spec ni tak susah dah lah. Cuma patent claims ambil masa sikit, and then the rest just copy paste, you rearrange. Basically the content is there. That's why kalau patent agent you bagi research report kat dia nak tulis pun senang. Dia nak kalau research report semua dah ada, tapi itulah kalau report tu not ready for publication, maybe you tak ready untuk bagi kat patent agent, you just bagi based on what question will be asked untuk dapatkan details untuk research report. Okay, ini steps patent drafting procedure. Kalau di dalam bengkel yang Prof Srimala tadi ada mention, kita akan cuba follow the step. It's not contingent, tak perlu ikut steps ni actually, cuma ini guide lah untuk mudah menulis dia punya patent drafting to patent specification. Because in patent specification dia banyak repeated content. That's why we start with the most important things. The patent document start with step number 4. The steps 1, 2, 3 is kind of preparation before writings. Okay, patent drawings. If there's any technical invention, usually ada patent drawings. Except maybe chemical, there's no patent drawing. Okay, no photograph allowed. So technical drawings. Okay, like this example for the mechanical related. If there's a software related, should be ada macam flow chart, diagram of the system atau screenshot. Kalau electronic ada circuit diagram atau component diagram. Tak perlu circuit diagram. Circuit diagram akan jadi complicated, boleh juga hantar, tapi better kita not strict ataupun terlalu ikut circuit diagram. We just send the component diagram to shows the layout of the invented diagram lah, invented electronic system yang you nak claim. Kalau dalam bidang lain, apa-apa yang related berkaitan lah, graph apa semua. Kalau chemical related ada graph ataupun elektron microscope punya gambar kan, itu semua yang sampel, yang outcome result semua tu boleh masuk. Itu ada exception, boleh masuk photograph kalau yang sampel microscope punya gambar. Okay, and then the technical features of invention. Yang ni kena identify. Yang ni selalunya tak menjadi issue because the inventor usually know best the subject matter and can identify the technical features. Just so that you need to identify in terms of patent styles. For mechanical related or something like this, just name the components. The components shall preferably name ikut industri punya practice lah, supaya standard. Boleh you nak name differently, kadang-kadang ada juga yang name differently, tapi kalau kita name based on industrial standard, itu lagi mudah lah, sebab everybody can understand the invention or the component name lah, sebab ini memang diguna pakai di industri. Okay, prior search and analysis. Ini yang saya akan step tadi. Ini yang penting dibuat sebelum menulis, before you write the patent specification. After you write the patent specification, patent examiner akan conduct another prior art search analysis juga. This why you conduct the prior art search first untuk elak berlaku novelty di peringkat fundamental. Okay, prior art ni apa dia? Prior art ni prior document lah. Whatever has been made available to public, whether published, written, oral description by use by the people related to the industry. If you just invented and keep the document in library, not available to public, it's not considered as prior art. The library or any locked places that you simpan dalam kabinet or whatever, it's not considered as prior art. Kalau library itu pun ada limited access pun, kita tak kira sebagai prior art. Tapi sekarang ni mostly apa-apa content available for all in internet, biasanya search pun akan guna sebagai internet lah. Ini akan berlaku yang macam saya kata tadi, patent right boleh lost. Dulu masa saya jadi patent examiner ada jadi satu case, nasib baik tak grant lagi masa tu. Kita cuba cari prior art, patent examiner cari prior art based on the invention, memang tak jumpa related invention. Invention tu related dengan palm oil industry juga. However, the document about the invention dah already known to the people in the industry. Ada kilang kilang proses FFB tu fresh fruit bun yang palm oil tu, dah well known the invention. Cuma orang yang terlibat lah. Examiner macam saya ni mana ada masuk kilang sawit kan, kita pun tak tahulah ada invention tu. Yang kita tahu yang mana available in the internet pun tak cerita in details. These things happen because the original invention tak file patent di Malaysia. Inventor dia pun memang company Malaysia, tapi dia tak file patent. Dia punya employee keluar daripada company itu, buka satu company baru, bawa the invention dan file patent, and then try to take action against the former employer. These things happen. Former employer tu tak puas hati lah nak kena saman apa semua, but dia tahu the document the patent has been the invention has been invented before, tak patut, it's not new already for the people in dalam industri tu. And then they provide the document to the patent office untuk examiner consider sebagai prior art. Tapi at first kita tak mau terima lah, sebab kalau terlalu small community saya tahu it's not considered as prior art. But then they list down about 20 or 30 factories yang dah memang guna. Okay, it can be considered as prior art lah for people related to the industry. We consider the documents as prior art, and the patent has been at first lah we keluarkan surat bantahan saying that it's well known already, it's not novel, so it cannot be patented. Itu rare case lah, but can happen.
Encik Radhi, tumpang tanya, is it okay for this case, macam researcher daripada USM, commonly whatever finding daripada lab mereka, commonly they try to have a paper lah, publication. Jadi dan apabila publication tu start publish, and waktu tu baru datang, aku nak patent ni. Jadi in this case, we have grace period, Encik Radhi?
12 months grace period, 1 year only.
1 year.
From the date of publication of the said research paper lah. Macam dah berlaku juga, usually happen kat university juga. After 2-3 years, they file a patent, and dia punya sendiri, dia punya publication paper jadi prior art. Because the subject matter is the same as patent, so not novel lah. Kena adverse report lah. That's why sebelum you publish paper, kalau you intended to file a patent, better file a patent within the grace period or prior to the filing, prior to the publication of the research paper. Because nanti jadi sendiri punya paper jadi prior art.
Sebab saya rasa ini kena ada reminder kepada all researcher juga, sebab sometimes we miss this thing dan collapse lah kita punya application.
Ya betul, akan jadi tak shock lah kan, kita punya paper jadi prior art sendiri. Tapi dah more than 12 months dianggap as prior art. untuk sendiri punya invention lah. Okay, jadi untuk contoh simple example lah untuk private search. Private search boleh buat banyak free databases lah. For example, Google Patents like this, atau lebih komprehensif lagi banyak database-nya adalah Espasnet, itu European Patent Office. Dia cover banyak negara lah. Malaysia pun ada, tapi cuma abstract lah. Tapi lebih untuk keywords. Google Patent lebih friendly lah untuk keyword search. Google Patent saja pun dah ada banyak dah, banyak negara. Main countries lah, like US, Japan, China, Korea, and Europe lah. US saja ada maybe 10-11 millions of patents, plus China every year 1.5 millions patent application published every year. Sekarang 4 tahun dah 6 juta patent. Dia dah banyak juga. Dia pun walaupun dikatakan dia banyak meniru, tapi dia juga inventif. Dia menghasilkan teknologi baru. Kalau you tengok number one patent filing company adalah Huawei di dunia. Huawei dia banyak file patent, especially yang related dengan dia punya industri lah. Okay, bila nak buat patent search ni, keywords yang digunakan penting. Maybe the keywords in your research is technical jargon dia tu too specific. You need to come up with broader technical broader keywords. For example, ini kalau dipanggil, okay, ini panggil chair, okay, kalau memang you invent office chair, you letak office chair lah. Sometimes you need to insert narrower keywords, sometimes you need to insert broader keywords. It depends on the search. That's why patent search ni bukan one day punya job lah. That's why patent agent charge mahal juga 1,000. It takes some time nak mencari dokumen yang related to your invention. Kalau play with keywords memang takes time sikit. Kalau dalam masa saya kerja patent examiner dulu, kita basically first mula-mula kita cari by keywords and then kita cari by pattern classification. Pattern classification ni memang narrow terus. Kalau masuk kelas dia tu, memang kita jumpa very related invention dengan kita punya invention lah. Paper yang kita jumpa, prior dokumen yang hampir sama. Kalau masuk keyword ni very broad lah, keluar result maybe thousands, 10 of thousands. Nak kena go page by page. Tapi kalau masuk by class, it's very narrow. Yang tu kalau kelas saja, saya kursus 2-3 hari lah. Nak belajar pasal kelas ni. Kita panggil IPC, International Patent Classification. Dia ada A, B, C, D, E, F, G. The main class lah. Kalau mechanical, F. Kalau electronic, I think E or H, saya lupa dah, lama dah tinggal lah, 5-6 tahun nak kira. Tapi mechanical tak ingat lah sebab background mechanical invention macam tu, memang F. F tu very broad, ada F16K sampai beberapa digit lah untuk the classification. Kita masuk, memang very narrow dapat result dia. Okay, in this case kita kena, kalau main using keywords, kita kena play with keywords lah. Macam office chair, for this kind example is mention ni, ada macam leg support, kita office chair with leg support, office chair with leg rest, or reclining office chair. 3 types of keywords, three different types of result lah akan keluar. Okay, this is the feature table yang I mentioned before, yang examiner pun guna macam ni untuk identify whether the invention is novel or not. From the invention parts, ni kita list down all the technical feature. Macam tadi steps number 2, identify the technical feature. We list down here all the technical features related to the invention. In this case, invention is about office chair. Is the main class, the main invention is office chair, and then the features is the base, caster, and so on. We list down according to masing-masingnya ciptaan lah. Kalau proses, kita list down the process. This is the product. Kalau the process, kita list down what is the steps. And then the next column yang bahagian D1 tu, ini panggil D1 lah. Kalau document 1. Kalau banyak yes daripada no, mana dia elemen novelty dia agak kurang. Tapi baguslah kalau ada no. Kalau semua yes, tak baguslah. It's not novel. Dalam kes ni, the invention is novel because about 5 features yang tak sama. D1 is a normal office chair. Okay, in case the invention yang prior art kita jumpa adalah normal office chair saja, tak ada yang ada leg support yang invented, yang kita cipta tu. Jadi ada elemen baru pada ciptaan adalah macam tadi ada soalan yang related kan, yang ni yang so tu patutnya dia buat macam ni lah. Biasanya dia buat macam ni untuk identify the novelty features. And then kalau ada no invention yang elemen technical feature yang tak sama, this one is bagus dan kita consider ada novelty features di situ. However, kalau kita jumpa satu prior art, for example dalam kes ni US 2013, ada satu dokumen yang macam nak sama tapi dari segi gambar dia tak sama. Sebab patent punya protection is not based on drawings, it's based on the patent claims, the wordings in patent claim. Walaupun dia punya figure, dia punya gambar raja tak sama, dia punya scope of protection is based on the wording of the claims. That's why bila kita list down the technical features, we compare the wording of technical features dengan drawing prior art. Sama juga, dia punya proses ni sama macam nak tentukan infringer. Ada orang tiru invention kita, kita put side by side, kita punya patent claims dengan dia punya, maybe kalau ada produk dia lah, produk infringer tu yang meniru tu. We read the claims, if all the features in the claims are there, less tak apa, jangan more. Dalam patent claim, kalau the infringer ada 10 elemen, the patent claims ada 5 elemen, meaning that the basic technology of our invention is being used by the infringer. We can still take action against the infringer. Okay, in this case, walaupun dia punya gambar raja or design is not 100% this. Okay, ada soalan tu tadi?
Ya, kita ada satu soalan daripada Dr. Fatimah. Encik Radhi, semua D1 boleh ke include dalam claim walaupun ada prior art untuk sebahagian D1 ini, atau kita claim part yang novel sahaja, rujuk kepada chair dia?
Okay, in this case, bila kita construct the patent claims, kita kena masuk semua plus the novelty element. Dia ada tunjuk satu sampel patent claims yang elemen sama tu, the yes part we put in the bahagian awal, kita panggil preamble of the patent claim, and then elemen baru yang no kita put di bahagian characterized portion dekat bahagian bawah, itu to show that there's a two parts claim. First part is the recognized features that same as prior art, and the second part is the special technical features that we claim as new. From there, bila sampai ke peringkat substantive examination, patent examiner will conduct another search and construct another table based on our claim to determine whether yang kita claim sebagai special technical feature plus all the features adalah baru atau tak. Maybe dalam kita punya prior art, kita jumpa 5 elemen baru yang no. Examiner conduct search, maybe dia kata okay, not 5, only 2, or maybe kalau 2 pun okay lah. Kalau semua tak lepas, okay, jadi isu lah. So, okay, in this case macam saya tunjuk ni, example ni, maybe kita tak jumpa yang US 2013 ni, kita cuma jumpa yang D1. But when examiner conduct patent search, dia jumpa yang US 2013, at a glance boleh nampak the person in dalam background dalam teknologi ni boleh nampak almost the same. Untuk determine whether same or not, buat satu lagi table based on D2 2013, kita panggil D2, and then kita list down the technical features, identify, tengok semua yes. In this case it's not novel.
Cik Radhi, satu soalan, mungkin ini soalan daripada researcher juga semuanya. Dalam melihat kes seperti ini kan, not novel, jadi adakah perlu researcher semua put many claims, ataupun we have to limit sebab ada certain claims sahaja, ataupun kita boleh put all our claims, sebab look like macam try to avoid daripada not novel ni, researcher mula bubuh banyak. Jadi apa pandangan the best macam rule of thumb lah?
Okay, in this case, kita tak buat claim lagi. Kita cuma list down technical features. From the technical feature akan jadi claim kemudian. Bila kita list down the technical feature, dia mesti related to the invention. Kalau ada banyak-banyak, there's no limit because some patent documents ada 40, maybe hundreds claim. If you list down lots of technical feature, meaning that you want to construct a lots of claim lah. Again, usually okay, dalam patent the first 10 claim is free, additional claims ada extra charge. That's why bila kita buat write up tu dalam bengkel saya buat tu, saya kata not more than 10 lah, untuk elak additional fee. Tapi kalau you willing to pay, no problem, because you want to claim as much as possible, up to you, it's your invention, you want to claim. Tapi kita advise jugalah jangan claim terlalu narrow, nanti akan jadi terlalu kecil protection. Infringer boleh circumvent the invention, dia cipta something baru, something else yang almost the same tapi dia terlepas daripada action yang boleh kita ambil.
Cik Radhi, kira boleh I put this way, maksudnya sekarang ni kita jangan lebih 10 sebab 10 akan having another charge, but 10 ni very comprehensive and we not too narrow sebab kita nak pastikan kita selamat supaya tak di...
Okay. Yeah, we choose the best 10 lah. The best 10 yang possible, yang kita, the inventor rasa, okay, this is the 10 claims that I want, but maybe there are another 10 or maybe another 20 claims that can be put there, masuk di dalam detailed description as reserve, as disclosure. So that walaupun dapat the claim for the first 10 claims, the rest of the features included in the description can be considered as a disclosure to the public lah. So any inventor yang lepas tu nak cuba buat invention yang sama macam the rest of the yang tak limited per 10 claim, maybe additional 20 tu, dia tak boleh dapat patent lah, sebab prior disclosure dah ada sebagai prior art.
Okay. Jelas.
Okay, patent claims. This is the most complicated part dan the most important part of the patent specification. If there's any dispute kat mahkamah, the court will only look at patent claims. Ini pengalaman peribadi lah. Ada satu case masa 2014 dulu, saya jadi witness, satu expert witness, dipanggil ada dua parti yang dispute. Saya punya the case that my patent case yang saya granted, patent owner dengan dia punya competitor dalam industri sama. My first experience lah masuk mahkamah tu. And then I terutama yang IP nya court, and then I know lah yang dispute cuma bahagian claim. Dia tak tengok drawing, dia tak tengok bahagian lain. Tapi bahagian lain diperlukan as part of the patent specs punya requirement. But if there's any dispute in court, only patent claims will be scrutinized lah, word by word. That's why what you write will determine the scope of your protection. Dari terlepas satu perkataan, terlepaslah dia punya peniru tu. Okay, dalam patent claim boleh ada beberapa jenis claim lah. For example, product claims, process and method claim, or use claim. Yang paling threshold, yang paling kuat usually product claim, because easy to identify infringer in the market. They make a product, they sell in the market, we can identify the product is infringing our patent. Senang tengok. Ada produk, boleh identify. Sometimes kita cuma claim process, method atau system. It's usually about the software related invention, memang masuk ke our process method claim. Ini susah sikit dan kita kena reverse engineer. Kita kena tengok balik lah whether the method used in the system ataupun dalam industri, kena hantar industrial spy ke apa nak tengok ke, itu pulang lah, itu peringkat kemudian lah. Nak tengok betul tak dia meniru proses kita, itu kita take action later on lah kalau meniru proses atau method claim. Use claim ni new use lah, benda tu dah ada, the product is there, process is there, cuma new use. Common example yang senang cerita ni macam Viagra kan, Viagra ubat initially intended for the heart attack, for heart treatment kan, tapi industri dia dapat jumpa second use, kita panggil, untuk ED. erectile dysfunction apa untuk rawatan tu kan. And then siapa yang jumpa, maybe not the same company, maybe not the same product owner, another company will claim the use of the product for that kind of treatment lah, untuk second use. So use claim normally chemical ataupun pharmaceutical, ubat-ubatan lah banyak. Dalam engineering related ni very rare lah. Rasanya tak, selalunya tak jumpa lah use claim untuk engineering ni, selalu chemical or pharmaceutical.
Dia macam formulation lah, formulation yang sama.
Yes.
Dia pakai.
Ya, tapi cuma application different application. Maybe the masa product ataupun formulation tu dibuat intended for one application, and then later on maybe a few years somebody else jumpa, mungkin not this application, second use, different from the first application, can also be used for the same product, and then the another party tu akan claim sebagai use claim. Tak strong tapi boleh masuk claim, tak apa kuat lah. Okay, ini example tadi. Example product claim yang tadi saya kata ada seperti soalan tadi, whether kita nak masuk semua feature or not. Okay, kalau kita claim yang macam tadi based on the first table dengan normal office chair, bukannya US 2013 tadi. Okay, kita identify ada 5 elemen baru. Tapi di sini masuk tak semua lah, mungkin 2-3 saja, tak semua, dia reserve. Dia ada strategi untuk menulis. Maybe 5 yang new element, maybe masuk 2 saja. Ini cara penulisan pattern lah. Dia akan masuk elemen base, armrest, backrest tu semua dah ada macam prior art. Cuma leg rest tak ada. Dia panggil leg rest. Leg rest is the new element. Characterized in that is the the border between the preamble and the new features. The leg rest and then backrest is adjustably connected, dipanggil. Maksudnya dia reclining lah. Dia tak panggil recline. Boleh saja masuk perkataan recline. Memang straightforward lah. Tapi dia boleh panggil juga adjustably connected. Ini model, not exactly the same. Different kind of words can be used. Depends on what kind of field you want. Kalau tak mau panggil office chair, you boleh panggil juga a chair. Dia akan jadi lebih broad. Lebih broad. Jadi bila lebih broad, prior art akan konflik pun lebih banyak. That's why kita narrow sikit. Lagi itu nak cari, that's why kita buat prior assert untuk dapatkan the right balance. Kat mana broad, kat mana narrow. Nak dapat the right balance tu. Itu pentingnya kena buat prior assertion. Ini example method claim. Ini software related. Method claim must use gerund, ing, converting, selecting, determining, transmitting, something like that. Kalau in BM kata kerja lah, in English ing, gerund, ing, method claims. Ini format yang betul lah untuk menulis method claims. And then ini example use claim. Yang ni use claim untuk chemical related lah. Use, dia kataan start with use of apa, something like that. Ini chemical related example. Okay. Memang usually related chemical atau pharmaceutical. Sorry. Okay. Okay, nampak face mask Encik Mas? Saya takut lari tadi. Okay. Okay, define, okay. Patent claim define the scope of protection of the invention. Contoh di sini, kita cari bubuh example yang simple. Face mask. Before the surgical mask yang sekarang panggil face mask. Face mask initially panggil surgical mask kan, yang jenis ikat ni. Prior art. And then improve the invention to make it simpler for the user to use. Guna ear loop. Yes, bila kita buat patent claims tu, kita panggil a disposable face mask, sebab dah memang commonly known face mask, a disposable face mask. Ada filtering portion, sama macam prior art. Dia punya attaching means. Okay, yang ni kita punya style penulisan dalam patent claims. Kita cuba letak as broad as possible lah dia punya terms. Of course, we can call it string. It's very lagi narrow. Tapi kita kata attaching means in the broader sense lah. Install ataupun apa nama? suit apa kita kata install lebih broad lah to set filtering portion. Lepas tu characterize index, ni elemen baru lah. Attaching mean dah ada, cuma dari segi functionality or a new way of doing something tu dia different lah, guna ear loop. Ini barulah kalau masa ni lah untuk example ni. Okay, before kena ikat, dia punya improvement untuk memudahkan lagi invention ni guna ear loop. Ada juga invention berkenaan face mask ni, ada yang tak ada attaching tak ada string. That's why kita panggil attaching mean. Ada inventor dari Kedah. Dia file earlier dekat-dekat nak PKP tu dia datang. Saya ingat lagi sehari sebelum PKP tu dia datang file patent untuk design baru face mask. Dia pun medical background. Tak ada tali. Dia dah buat dan jual. Saya cuba beli tapi habis stok. Dia buat jual sendiri. Dia tak ada, dia cuma ada filtering portion. Dia punya attaching means tu adalah adhesive, pelekat. That's why kita panggil attaching mean. Kita kalau boleh tak mau panggil string. Kalau kita panggil string, inventor tu dia buat tak ada string, dia guna adhesive. Adhesive it can be called attaching means juga. Dia letak macam adhesive, melekat sikit, lekat terus saja. Dia punya face mask, bentuk macam face mask yang invention tu, cuma tak ada tali, cuma lekat. Jadi mudahlah dia. Dia punya selling point kata mudah untuk orang berhijab lah. Orang berhijab lekat di mulut saja. Pak dia disposable lah, tak perlu nak guna apa kan, dia lekat di mulut, dia ada adhesive, dikeliling sampai ke dagu ni, memang function lah. Dia claim about 95% tu filtering, dia test dengan nasak pun tak ada video YouTube dia dekat website yang dia jual tu. Memang function similar dengan yang ada string ni juga, yang ada ear loop ke ikat ke. That's why bila kita nak mendraft menulis patent claims ni, we try to imagine what kind of circumvention that patent infringer boleh buat. Kalau kita kata string, tak lagi orang buat tak pakai string macam mana? Macam tu kan. Macam ada dah berlaku. Cuba kita kata attaching mean ni cover bukan not just the string but also any kind of attaching means that possible come up lah. Macam contoh adhesive pun attaching means. Tapi dalam kes ni kita kata attaching mean ear loop, memang limited to ear loop lah. Kalau we come up with the first invention yang nak try cover ear loop ke adhesive ke apa ke, boleh letak attaching mean saja yang lebih general. Sorry. Suka keluar ni. Ada tak? Okay. Jemaah ada ke?
Ni tak IP apa lagi Cik ni Radhi? Kena try to share again.
Tak ada.
Masih belum.
Dia lari sikit.
Okay, nampak dah? Mungkin Cik Radhi boleh slide presentation. Okay.
Okay, kalau nak claim nak bagi broad lagi, tadi kita mention a disposable face mask. Kalau you want to make it broader, you lose the disposable terms. Because now ada yang reusable kan, yang face mask yang daripada fabric yang reusable. Kalau kita mention disposable face mask, termasuk dalam court dari pertikaian or whatever dispute, the other party kata maybe dia buat yang reusable, dia boleh escape. Because dia kata dia punya invention reusable, not disposable. So if you write the claim, a face mask is very broad. Disposable or reusable pun masuk sekali lah. That's why every word you use is very important. Try to avoid dimension, shapes, the particulars yang limiting the technical feature atau the scope of protection. Okay, ini satu invention, computer related method ini. Ianya dah lama juga. Ianya adalah dari Uber, US 2014. Kalau tengok ini method claim lah, dia buat sistem ni. Kalau the first Uber ni dia dapat patent, dia akan jadi e-hailing punya prior teknologi lah. And then bila dia buat analisis, dia tengok potential siapa nak infringe, atau dia nak infringe orang. For example, kalau ada Grab, okay, ada tak dia punya wording. Ini kalau nak buat feature and table analysis macam yang sebelum ni, tapi kalau methodnya style, sistemnya style, kita nak identify whether kita novel, kalau kita cipta kemudian, kalau kita cipta dulu nak tengok identify whether invention ini apa the other party infringe kita punya invention. In this case, kalau patent claim yang as Uber file kat US ni, kalau kita buat analisis tengok adalah sama saja, display apa semua dia punya feature ni sama, walaupun dia punya user interface pada apps tu different, tapi dia punya feature adalah sama, basic features. Unfortunately kat US pun Uber tak dapat granted patent. I'm not sure why. Saya tengok dia punya dia punya history tu, dia banyak change hand. First Uber as the owner and then change hand to Golden Site, whatever lah, ada macam-macam JP Morgan and so on lah, yang major company. Last sampai 2019 dia tak granted. Macam dia Uber memang big company, dia memang make money. Kalau dia dapat IP on this, IP pun boleh generate income lah on top of the business. Kalau ini sebagai prior art, it's not novel. Tapi kalau potential infringer, memang infringement lah berlaku. This is how you determine infringement. Okay, and then summary of the invention. Ini simple je lah. Summary of the invention ini basically macam summary of the research. You can copy paste balik kalau dah ada. Kalau tak ada, basically kalau write up dah ni, kita ambil balik claim, kita letak di sini, kita tulis balik in normal sentence lah. Okay, technical field, background art, ini simple. Okay, kalau tengok okay, kalau kita back semula, kita start dengan patent claims, tapi patent claim tak duduk di muka surat pertama, dia duduk dekat belakang kalau tengok dia punya format susunan. Okay, technical field ada dalam muka surat pertama, tapi kita tulis kemudian. Ini dia punya flow untuk mudahkan up lah. Kalau nak start from the technical field pun tak salah, cuma kita selalu start dengan the most important thing dululah bahagian patent claims. Okay, ada title of the invention. Okay, patent title usually very simple. Office chair. Walaupun kalau nak letak office chair with leg rest pun boleh. Selalu kalau tengok title dalam patent ni banyak benda title yang sama. The same title but different invention. Subject matter bahagian yang the most important thing orang tengok adalah bahagian claims. Walaupun title tak memberi dia punya kontrak tak banyak. Cuma jangan title totally different lah. Tak ada kena-mengena dengan invention tu tak boleh lah. Sebab nanti orang nak search dokumen jadi susah. Okay, and then the background art is basically problem statement. That's why kalau dah ada problem statement dah dalam research tu, ambil copy paste je. Problems only. What kind of problem you want to solve? Sebab problem ni juga akan menjadi supporting parts kepada claims when ada bantahan from the examiner. Maybe the novelty lepas and then the inventive step or obviousness, ada objection on that. The problem statement maybe can solve that part because inventive step is very subjective. Unlike the novelty, novelty is very objective, one-to-one. 100% the same is not novel. But for the inventive step, obviousness is depends on combination of invention that cannot simply combine. Examiner maybe simply combine the two documents and say that it's not inventive. However, dalam problem statement, maybe ada mention something yang the combination of invention tak solve the problem. That's why ini bahagian penting lah. Kena let mention the proper, what kind of problem you want to solve, bagi clear. Tak perlu banyak, maybe satu or dua paragraph. And then kena ada juga citation lah. Same research report pun ada citation, tapi here and there lah. I pernah research report selalu you cited the publication yang dia, but in patent document usually kita cited di bahagian background art. Boleh one or more lah. banyak, up to you. Satu pun dah cukup untuk patent citation. Prior art citation not usually patent document lah, boleh juga research report, journal and so on as citation. Okay, brief description of the drawings, if any. Chemical related, we tak ada. You just mention what's the drawings about. Tak perlu masuk drawing di sini. Just mention figure 1 is about what, figure 2 is what, side view ke apa ke. This detail is very important. Detail ni adalah the subject matter yang cover, macam like I mentioned before, kalau 30 claims you just want to include 10, the other 20 you masuk di sini. Plus the existing 10 lah. Kena ada semua lah, not just the extra. Okay, ini just an example. You describe the invention based on figures. Lagi banyak figure, lagi banyak description kena tulis lah. Cuba write as much as possible, lagi banyak lagi bagus, sebab you try to disclose as much as possible about the invention, but not too much lah, because kalau too much dah disclose habis know-how, orang tak akan refer kepada kita untuk advice. Dia ada teknik dan taktik in writing patent description. Try not to disclose 100%. Maybe 80% is enough, just so that people can replicate or test the invention whether it is working or not. The other 10% is the know-how you keep to yourself. When they want to make the best invention, they need to come see you and then negotiate lah. You want to know macam mana boleh come up with the invention yang the best result lah. Okay, and the claims must be supported by description. Whatever in the claims also described here in the details. So you have 30 features in the invention, all 30 should be here, plus any other lah yang kalau you nak masuk. Okay, abstract. Biasa kalau research report pada abstract, sini pun ada abstract lah. You just put there, atau just simple ambil the first claim, letak you rearrange. Contoh macam ni. And then ada title di sini, and then ada most related figure. You just mention what kind of figure related to the abstract. That's it. Tak perlu letak the figure itself kat bahagian sini. Figure semua kita letak di bahagian belakang, di satu section, yang drawing section. No drawings in the section claim abstract. Drawings all in the drawing section. And don't forget to label the drawings based on the technical features available in the detailed description or in the claims. Chemical related lebih mudah lah sebab tak ada drawings. Kalau buat patent spec chemical related yang tak ada drawing tu lebih mudah untuk prepare dokumen lah. Kalau ada drawings ni, you try to pick the best drawing tu. Tak perlu, kalau ada 10 drawings, up to you. Kalau semua related, you include all lah. Kalau just one drawing is enough, one drawing. Okay, this is how you susun balik lah dia susunan the patent spec. Start with title, technical fee and so on until the drawings. This is according to Regulation 12 in Patent Act. It's not just tak boleh buat tunggang balik, tak boleh buat claim di depan apa semua. It must be according to this susunan lah. Okay, this is the formality requirement that I mentioned before. Maybe subject matter, novel and so on. Tapi kalau you tak comply dengan formality requirement ni, boleh kena reject juga patent tu. Simple matters ya, page number and so on, line number. Ini requirement dalam Patent Act. Bukan saja MyIPO ni, sebab dah ada dalam requirement Patent Act, jadi kita tetapkan macam ni lah. Page number, top and center, walaupun dalam report kita boleh buat bawah ke penjuru kiri kanan dia tak apa, tapi dalam patent dokumen mesti top and center. Every fifth line, ini 5, 10, 15 ni dalam Microsoft Word boleh buat automatic. Margin 1 inch lebih kurang 2.5 cm. Top kiri kanan atas bawah semua 2.5 lah. Tapi dalam drawings jangan ada line number. Dia tak boleh ada pula dalam drawings line number tu. Okay, dalam claims mesti ada reference number in parenthesis dengan kurungan ni mesti ada refer to the drawing. Kalau ada drawing lah, kalau chemical related tak ada drawing tak perlu ada reference number. Kalau ada drawing mesti letak number dengan parenthesis dan mesti consistent. Kalau caster 3, semua caster mesti 3. Tak boleh caster 3, caster 5. Kalau ada caster nombor lain, okay, first caster, second caster. First caster number 3, second caster number 5. Well, maybe at a different caster, you want to differentiate the technical feature, you put the first whatever, second whatever, maybe the distal, the proximal, the different kind of writing style. Claim shall start in new page. Ini memang kena new page, tak boleh letak sambung terus. Mesti dalam new page and must be in one sentence. One claim, one sentence. Ini kerap berlaku kalau yang tak biasa menulis, dia akan masuk 2 or 3 sentence dalam satu claim. Kalau perasan dekat every line tu dia ada semicolon ataupun comma boleh letak lah. And the last ni baru ada full stop. Ini style untuk pattern write up. Apa just to share lah. Abstract ada title macam tadi, reference number. Abstract also start in new page. Drawings, before dia tak particular on page number, tapi ada satu case pernah dapat objection mesti letak style macam ni, infraction apa macam pecahan based on the number of sheets. Kalau ada 5 sheet, berapa per 5 kan, 2 per 5, 3 per 5, because we want to know number of sheets of drawings lah. Yang ni yang related ni, number of drawing, one sheet or 2 drawing per sheet, up to you. Drawing start in new page and the format of the format based on number of sheets. Reference number, don't forget in the drawings. Okay, the filing procedure. When you complete the pattern spec, what kind of filing procedure? When you want to file a patent, you must file Form 1, the request for grant of patent. This is the fees and form related to the filings. Form 1 costs about 290, and then Form 22, 100, just increase from 80 ringgit last 18 March itu naik daripada 80 ke 100 ringgit, naik 20 ringgit sajalah. Form 22 ni, the statement justifying the applicant ini very important for invention in university lah, sebab this is will justify kenapa university nak claim the invention, sebab by right the invention belong to inventor. But since the inventor is employee of the university, employee of an entity, you need to submit Form 22 so that the entity, or in this case, university, has the right for invention. And then Form 5, request for substantive, so that patent examiner can conduct patent search, and then substantive examination process. If everything okay, and then it will be granted. Okay, the Form 5 can be deferred, not more than 18 months. So from the minimum filing is Form 1 and 22. Okay, deferment of Form 5 usually not more than 18 months. However, you can extend up to 5 years, 3 months by filing Form 5B. In case you want to delay, I think rasanya semua tak mau delay lah, kalau boleh nak cepat dapat granted kan. Okay, jadi you file together all these 3 forms before the 18 months, and then after that baru ada queue untuk examination. Why 18 months ni tak buat apa-apa? Memang tak buat apa-apa, dipanggil confidentiality period. Ini memang international practice. We must comply with international practice. 18 months memang simpan saja. Kita tak file tu memang tak masuk queue untuk examination after 18 months. That's why kita bagi chance kalau kalau ada kekangan bajet awal-awal filing tu, tak perlu hantar borang 5 lagi. Cuma submit 1 dan 22 saja. Itu minimum filing lah, 390 only. Tapi complete filing mesti kena ada form file lah. About altogether 1490 lah, about 1500. Sorry. Okay, and then the 18 months, after 18 months, if you don't submit the Form 5, we assume you're not interested to proceed with the patent filing, it will be deemed withdrawn and open to public inspection lah, after 18 months. Kalau proceed pun memang kita open juga untuk public inspection. Kalau other country, like I said before earlier, they akan publish the whole document. Tapi di Malaysia cuma open to public inspection. I tak tahu lah kenapa, sebab kalau nak tengok full document kena beli, satu RM30. Jadi boleh tengok setakat abstract saja free. Selalu after 18 months, about 12 months, there will be first office action, grant or adverse. Kalau grant, no problem, you get the certificate granted. If not, if you issued an adverse report, you need to reply the adverse report. Usually tak ada additional fee dari MyIPO. Kalau guna agent adalah, kalau guna, sebab dia nak prepare the counter argument lah. Kan? Dia argument untuk objection tu. Kalau MyIPO tak ada charge, unless ada macam typo error, something like that, itu mungkin RM80 ke RM100 dah naik. Kalau then everything clear, will be granted 20 years protection from filing date. And don't forget, ini pun penting juga, ada annual renewal atau maintenance fee tadi. Kalau tak bayar, dia patent right akan hilang. Macam I mention ni, minimum fees adalah 390 sahaja. To secure the filing date and to get the patent application number. We call it patent pending. Nak secure memang not costly, cuma complicatednya patent specification lah. Requirements untuk registration, ini yang diambil kira oleh patent examiner. First is patentable invention. Kalau ada, like I mentioned before, kalau ada memang technical aspect and so on, itu no problem lah. Selalu research memang patentable invention. And then mesti novel under section 14, involve inventive step, obviousness, section 15. Ini agak obviousness ni, untuk example obviousness, selalu kalau kita tengok power bank. Okay, power bank yang untuk dia macam bateri, portable battery. And then somebody came up, kata power bank ni nak recharge dia selalu guna plug lah normally. Tapi kalau kita letak solar panel macam mana? Ada kan dalam market, ada pernah ada saya jumpa dalam market, ada solar panel dengan power bank lah. Kita letak kat dashboard, kapal letak kat panas dia boleh recharge. Maybe not actively macam kat tapi passively recharge lah. Mungkin tak macam plug tu, tapi dia boleh charge juga. Tapi something new lah idea tu. However, for person in same field, kita panggil posita, person having ordinary skill in the art, orang dalam bidang tu, bidang bateri, bidang elektronik, kata solar panel dah lama ada, cuma tak ada lagi orang pasang dekat power bank. It's very obvious lah, kalau nak recharge ambil size kecilnya solar panel, lekat je lah atas wire masuk untuk recharge, and that's it, dia boleh recharge power bank tu. It's obvious. That's why inventive step tu, kalau obvious, dia tak involve inventive step. Kalau dia tak obvious, okay. That's why they satisfy the requirement of inventive step. Macam contoh power bank tadi, dia tak involve inventive step lah. Very obvious for person in this in the say background tu, person skill in the art, person having skill in the art dalam bidang elektronik, kata very obvious untuk pasang solar panel pada power bank. Jadi tak inventive lah. Mungkin dia tak lepas, tapi dia novel. In this case, alternatively, kalau tak mau argue lah, kalau tak mau gaduh panjang dengan examiner, tukar jadi utility innovation. Sebab utility innovation tadi ada soalan kan berkenaan tu, kan dia cuma melibat section 14 saja, novelty, inventive step tak ambil kira. Walaupun tak lepas untuk patent, dia boleh lagi dapat protection under utility innovation. Cuma
Radhi, saya nak tumpang tanya.
boleh.
So let's say researcher tu keen, memang dia nak juga pergi ke arah pattern, but right now kita ada elemen yang tercicir iaitu inventive yang kata ni. Jadi dia perlu buat something yang make it the whole process waktu rebuttal tu submit ke MyIPO dengan something new configuration supaya nampak berbeza lah kan.
Dia tak boleh edit subject matter, dia tak boleh come up with new features. Dia mesti existing features as disclosed in initial application. That's why kita macam tadi saya kata, write up di bahagian detail tu penting. Plus bahagian background art and problem statement tadi. Itu
Sebab saya rasa yang ni pun ada banyak kali case berlaku juga di kita, memang inventive kita fail, so we have industry dengan novel saja, inventiveness tak ada.
Bila dapat yang ni, sebabnya cara sebaiknya lah kalau kita nak insist on pattern, kita kena buat rebuttal counter argument lah. Memang kena karang panjang lah. Tapi yang itu topik lain lah. Dia ada apa, menjawab bantahan examiner tu, itu ada separate course on that lah. MyIPO ada buat satu course tu di HQ. Overcoming pattern objection, apa nama, tak lupa lah. Itu menjawab bantahan pattern examiner. Selalunya kalau dapat inventive punya objection, pattern agent, kalau guna pattern agent, dia jalan mudah dia kata tukar UI lah. Itu cara mudah. Sebenarnya dia boleh nak, kalau insist on that, dia akan mengarang panjang lah. Mengarang panjang dia akan charge lebih lah. Maybe kalau conversion selalu mungkin tak sampai 1,000 dia charge, kalau tukar jadi UI. Kalau nak mengarang panjang melawan, dia charge kurang-kurang 3-4 ribu lah. Dia nak cari balik, nak baca balik di mana nak boleh argue, the point for argument tu. Kalau initial application tak banyak point, peluru nak lawan balik tak cukup lah. That's why peluru tu penting masa di dalam bahagian detail. Saya selalu advise, tulis sebanyak mungkin yang boleh. Kalau ada research paper senang cerita. Kalau kadang-kadang inventor, selalunya yang saya buat course, all in there. Kan? Dia tak buat research paper, kata tak siap lagi ke apa kan, tapi all in there. Dia kata keluar semua write up tu. Dia tulis semua apa yang boleh. Tapi limited time lah kadang. Dia cuba tulis sebanyak mungkin. Itu sebagai reserve, peluru simpanan untuk melawan balik jika ada bantahan nanti. Ada soalan tadi kan macam mana? Sorry, cuba tak ada suara.
Okay, minta maaf. Kita ada 2 soalan. Soalan yang betul-betul relates dengan current utility innovation ni daripada Dr. Caciban. Is utility innovation considered the same as a patent or they are totally different category of IP? Adakah sama ataupun totally lain?
Utility innovation is the same as patent. Protection is the same. Protection period, protection law, all the same. The difference is only novelty criteria is taken into consideration for registration. However, all the other criteria is the same treatment as patent. Normally, I think all university not so keen on UI because of the criteria, the marking criteria. The MyRA criteria do not consider UI the same weight as patent. Actually, it's the same. I'm not sure why MyRA tak consider the same as patent. Actually, it should be considered the same as patent because it's under the same patent system, patent law, one law. It's not separate law. One under patent law. Just a small section there about UI. The registration only taken novelty as into consideration, not inventive step. Everything else is the same as patent.
Yes, sebab on let's say for the PRGS grant for example, so dia memang terus terang dia kata mahukan patent. So this is maybe some kind like UI tidak menepati kriteria yang kementerian inginkan lah.
UI dianaktirikan lah biasanya.
Betul. Satu lagi soalan.
Yes.
Satu lagi soalan kita tercicir sebelum ni daripada Dr. Zainuddin. Bolehkah some kind like Cik Radhi, success story and number of R&D university patented and commercialized, meaning that macam dah patent and mungkin generate money, menguntungkan institusi, mungkin Cik Radhi boleh share daripada pengalaman berapa banyak making money?
Usually actually lah yang making money ni tak banyak dan biasanya dia orang tak cerita. Tapi ada yang cerita lah, for example yang macam UPM, dia ada mention lah, tapi dia tak cerita in detail what kind of invention yang dia make money. Dia cuma bagi figures. I think 2-3 years back dia kata dalam 80-90 juta lah yang dapat return. Tapi what kind of invention dia tak cerita lah. Itu kena tanya directly lah, kadang ada ke rahsia ke apa. Itu masuk dalam media lah, itu saya dapat tahu. USM pun saya rasa ada 1-2. Dululah pernah saya pergi, saya tak ingat 10 years ago ke bila lama dulu, ada cerita success story, I think from Kubang Krian punya invention nanti. Dia ada medical ataupun vaksin apa tak, saya tak ingat lah, malaria related ke apa. Mana ni ada dululah. Yang betul-betul university lain memang tak ada yang ni lah, yang dia cerita secara straightforward of the successful story yang commercialized, but there are yang memang success, especially yang pharmaceutical related invention, yang come up with the new drugs, new vaccine, they are yang locally made lah. Itulah bila masuk in market.
Bila kita miliki macam patent tu, kita boleh licensing lah, selalu Cik Radhi katakan. So
Betul.
bila kita pegang ownership of that IP, okay, you nak guna kami punya USM, so licensing, so keep little bit money from that pun part of commercialize juga.
Yes, that's one commercialized. Okay, on that part nanti saya masuk satu slide, ada cerita sikit on commercialized. Okay, ini requirements lah. Industrial applicable, no problem. Itu memang you can mass produce, is very useful. It can be industry applicable and sufficiently disclosed and in the patent description according to regulation 12, I must follow the proper format and all the disclosure is the same as claims plus more lah. Kalau minimum must be the same as in the description and the claims. Okay, a little bit about non-patentable lah. Ini I go through cepat sikit lah. Non-patentable ini just untuk tahu je lah, tak mau go through detail. Okay, first is discovery, scientific materials and mathematical method. Discovery ni macam you found a new plant, for example lah, masuk taman negara jumpa pokok. You want to file the pokok, what kind of thing, tak boleh. It's not patentable. The mathematical methods and so on, it's not allowed. The formula, algorithm formula itself is not allowed, but a system using algorithm, that kind of algorithm is allowed. There must be some technical aspect that using the formula, that one can be patented. But the formula itself cannot be patented. Okay. Okay, plants or animal varieties other than man-made living microorganism can be patented. Or plant or animal variety cannot be patented. For example, this one, Onco mouse, an old patent. Patentable in US because there's a slight different patent regulation from in US and any other country and in Malaysia, because Malaysia basically follow European punya law lah. Kita panggil consultant dari European masa nak establish patent act dulu. Jadi basically memang follow European style. US dia lebih lax on that lah, dia macam-macam, everything under the sun can be patented lah kat US. Basically other country, kat US saja special, but basically other country, Japan and so on, dia memang very strict on what kind of things you can patent. Technical aspect no problem, but this kind of thing dia tak allowed lah. Okay, schemes, rule, method of doing business pun tak allowed. Ini ada satu example lagi, method of playing apa ni, game apa, snake and ladder ni ke apa ni. Kat US allowed, kat Malaysia tak allowed lah. Tengok susah lah tu. Dia tengok dia punya patent claim just method of playing tu, dia tak ada pun technical aspect di situ. Providing game board, dia bukan claim. Kalau game board itself can be patented, maybe if there's a new features there can be patented, but the invention is not claiming the game board, method of playing the game board.
Cik Radhi macam seni dia main lah, seni.
Ya, cara main, cara untuk main. Bukannya game board itself. Kalau game board itself is allowed, but cara untuk main tak boleh lah. Itu tak ada technical, unless selalunya tak libatkan technical feature, baling dadu, jalan-jalan ni kan. Mana ada technical features yang special technical. Okay, ini method of inducing aerobic exercise, method main dengan kucing guna laser pointer. You play with the cat using laser printer. It's not technical aspect. There's no technical aspect there. It's not patentable in US. Sorry, in Malaysia, but patentable in US. Okay, and then the business method. If you read the claims, there's no technical aspect. It's like regular people entering the shop and just shopping regularly, selecting the product, unless they include some feature. You need to click the product, for example, using the e-shopping like Shopee or whatever, Lazada. There's a technical aspect that you need to click and then enter the basket. You need to pay using the online payment system. That one can be patented. Okay, and lastly, method of treatment of human or animal body. Diagnostic method, but the method is for treatment is not allowed, but the apparatus tool used for treatment is allowed. For example, the scalping surgery pisau bedah tu, whatever tu kan, tu mungkin kalau ada baru punya design yang special boleh. Kalau ada tools to assist in treatment is allowed. The tools is allowed, but the method itself is not allowed. This is example of a US patent about the method of treatment not allowed in Malaysia. Okay, about the commercialization. Encik Muaz mentioned before kan, commercialization yang ni basic lah. Self-commercialization yang build and sell. Maybe ada dah buat, saya jumpa Prof semalam pun dia ada itu cerita sikit, ada yang buat startup, ada yang buat spin-off kan. Memang galak, banyak universiti lain pun sama juga dah galakkan spin-off ataupun startup untuk self-commercialize the invention. If the researcher invent something, maybe not depending on third party to commercialize it, the researcher can commercialize by themselves lah. It's a good idea untuk ni untuk self-commercialize. And then another one is licensing. Ini memang normal lah. You license the invention. Another thing is you sell the invention. You value the invention and then you sell out. You sell the invention one off to another party. In my personal opinion, I prefer selling the invention because you don't need to think about it. Because every year you keep come up with new pattern. So if somebody interested to buy the invention, why not sell it one off? But if they want to license, okay, you can keep the right and just keep licensing, whether it's exclusive or non-exclusive. Depends on you whether you want to sell or license or self-commercialize. Another one is actions against infringement. In patent, we call it patent troll. Unofficially, we call it patent troll. It's not morally right. It's legally is right. They can take actions, but it's kind of the other party can teraniaya lah. Kalau dia tak tahu, kalau dia memang infringe, yang dia tahu dia infringe, and that one memang right patut ambil tindakan. Tapi kalau tiba-tiba dia tak tahu dia infringe, tiba-tiba kena action. Banyak berlaku lah. Like macam yang example saya bagi tadi, yang insulated container yang import dari China tu. Dia import, dia tak tahu dia meniru. Ada patent owner tu, yang local tu, dia import, then they sell, tiba-tiba dapat warning letter saying that dia infringe patent owner punya patent tu. Baru dia tahu, dia terkejut, dia datang jumpa pejabat saya and then get advice, kata memang tak boleh escape dah, memang side by side compare dengan patent owner tu punya patent claims dengan dia punya produk yang dia import, 100% the same, tak boleh lari dah. Lastly dah sebut, dah ada settlement yang baik-baik lah, tak perlu masuk mahkamah, okey lah, settle lah. Kalau tanya saya, ini pun satu bentuk commercialization lah. You take action, you get the money lah. You get royalty or whatever compensation that you want lah. Don't come up with a capital for the product and so on. Tapi kena jadi macam polis lah, kena mata-mata, kena tengok lah, kena tengok apa nama what kind of product dalam market and so on, what import. Kadang-kadang terjumpa kan, person yang researcher ni kadang dia terlibat dengan produk tu and then maybe ada minat lah untuk produk yang related, dia tengok, somebody else sell the same thing. And then tengok balik patent claim, kalau sama, okay, boleh take action.
Cik Radhi, saya ada satu soalan Cik Radhi. Okay,
Ya.
let's say kita cakap kita ada patent on certain formulation lah guna microorganism, kemudian
Okay.
concentration sekian. So ada company ni dapat tahu the formulation, kemudian waktu kita nak, sebab kita monitor pun sukar nak nampak juga how dia guna concentration. So come to the point, dia kata saya tak guna pun how much concentration yang you guna, saya guna concentration lain, some kind like altering the numbers. Macam mana case tu Cik Radhi?
That's why bila kita masuk the numbers in patent claims, not exact number. Selalunya kita letak range lah normally. Kalau dia keluar daripada range tu, memang keluar daripada kita punya scope of patent. Maybe dia come up with less effective tapi doable. Dalam research maybe certain range tu yang efektif. Tapi dia nak lari daripada kita punya patent, dia keluar daripada kita punya range. Bila kita, that's why bila ada numerical value ni memang orang boleh tweak lah. Itu kalau normal patent claim memang not advisable tak numbering numerical value. Tapi dalam
So,
kita memang tak boleh lari lah.
Contoh Cik Radhi kan, so in the case bila dibuat kerja di makmal, so amount yang kita boleh buat sedikit sebab kita lab base. Jadi so bila dia nak buat secara besar-besaran, dia terpaksa macam OEM, third party lah. Jadi di sini yang kemungkinan IP tu boleh macam diciplak, kita bagi kat dia buat OEM dan kita kan monitor dengan ni lah sebab dia pegang kita punya key. Jadi macam mana Cik Radhi punya pandangan on this?
Okay, the other party OEM company atau dia manufacturing, dia sub to OEM.
Either lah, boleh jadi.
Itu okay. For example lah, okay, kalau the other party OEM ataupun dia sub OEM, dia yang responsibility kita bagi kat dia. When we ada negotiation untuk dia ambil kita punya produk, what kind of limitation, what kind of price yang dia patut ada. Bila kita bagi dekat dia, in case kita risau berlaku unethical punya keadaan lah kan, unethical punya keadaan tu kita kena letak
NDA lah.
Ya, NDA something like that lah. Tapi in case kalau dia just not for manufacturing, kalau dia manufacturing, itu jadi cerita lain. Contoh yang dia juga OEM manufacturer, kadang-kadang dia ambil, dia nak retest balik, dia nak tengok dia macam tadi Cik Mohd kata lah, lab scale lain cerita, lab production lain cerita. Bila dia nak sesuaikan dengan kilangnya manufacturing, dia mungkin ada beberapa step yang lain lah yang dia nak tengok boleh go through on the manufacturing line dekat kilang tu macam mana, adakah dia perlu invest something else, maybe alter sikit lab process tu. Kalau tak keluar daripada scope patent, no problem. Tapi kalau dia juga dia kata dia just ambil dan dah outsource kepada company lain, itu dah jadi dia pun tak tahu macam mana OEM company tu buat. Bila berlaku keadaan tu, kita kena letak clause lah, dia bertanggungjawab sepenuhnya untuk apa yang kita bagi sampel or whatever lah kat dia formulation. Maybe dalam kes ni adakah dia like eksklusif atau non eksklusif. Kalau eksklusif license lagi kena letak syarat berat lah. Kita maybe dia license dia eksklusif license, sebab kita tak boleh, bila eksklusif license kita tak boleh license kepada orang lain pula kan, dia satu-satunya yang pegang, and then dia ada tanggungjawab sebelah kaki macam patent owner. Dia kena monitor sebab kita tak monitor market, dia akan monitor market. Sebab dia exclusive license, dia macam ada half the rights. So dia punya responsible untuk tengok juga market, ada tengok supaya tak berlaku infringement to the product lah. Kena letak right lah kepada dia sebab kita bagi eksklusif. Kalau non eksklusif tu ringan sikit lah, dia pun tak ada tanggungjawab. Depend lah, kalau nak letak dia juga boleh, tapi tak kita juga bagi kepada orang lain, dia tak boleh jadi nak monitor ni lah. Kompetitor dia juga dapat kan. Kalau eksklusif tu kita boleh letak dia punya clause untuk tanggungjawab dia lebih berat lah.
Okey, Cik Radhi, kita ada satu soalan daripada Dr. Muhammad Hafiz Hassan. Assalamualaikum Cik Radhi. Jika patent difilekan di Malaysia, adakah coverage patent kita worldwide?
Okey. Patent seperti juga IP lain adalah territorial. File di Malaysia, protection di Malaysia. There's no international patent. Kecuali copyright, like I mentioned before, copyright. Tapi copyright ni more on artistic, literary, untuk penulisan. It's not about technical aspect of the invention. Itu worldwide protection. filem and lagu and so on. Tapi kalau pattern ni sama saja macam di mana-mana, it's territorial lah. Trademark, design semua territorial. Okay, patent infringement macam tadi saya mention kalau dapat warning letter of demand ni macam warning letter lah. Ini antara action kita buat bila content of letter of demand ni boleh buat sendiri kalau berlaku yang universiti punya universiti punya surat, ataupun nak buat sikit bagi agent lawyer lah, ada letter head legal firm tu selalu orang takut sikit. Dalam letter of demand usually we include the allegations of infringement, and then ada comparison of patent and infringement product. Kalau ada table tu juga ada analysis table between the patent claims and the infringement product lah. Kalau kadang-kadang normally bila dapat letter of demand ni, kadang kalau tak ada comparison of patent and infringement product, usually the other party try to take advantage. Dia cuba takut-takutkan kita lah. Maybe dia ada satu surat declaration pula dia akan sertakan sekali whether we agree that we are infringing the other party. Walaupun tak letak tu, kalau dapat letterhead from legal firm ni selalu memang dia pandai buat ayat lah untuk menakutkan kita. Banyak yang datang ke pejabat saya ni, ada yang tunjuklah surat-surat tu, kita tengok kadang-kadang dia dah sign dulu mengaku dia tiru, baru dia main tunjuk. Kata ini sebenarnya tak tiru pun, tak perlu sign. Tapi dah sign dah, susah lah. Dia sign dah hantar balik kepada sana kan. Actually dia banyak takut-takutkan saja. Kalau ada comparison, dia memang confident yang berlaku infringement. Another one is proper solution lah. What you want the infringer to come up with, ada nak licensing ke, nak offer dia beli ke, ataupun stop ke. Kalau kita juga buat we also manufacture dan sell in the same market, usually want them to cease and desist lah, manufacturing and then public apology pada kena meniru ni and so on, what kind of demand lah. And step number 2, kalau letter of demand ni tak dilayan, dia tak layan letter of demand, baru pergi ke patent litigation lah, masuk court. Tapi yang ni akan cost time and money lah untuk dua-dua pihak lah. Usually now 6 figures lah you want to use the lawyer legal fees. Kalau menang tak apa, kalau kalah susah lah, kena bayar ganti rugi and so on. Usually we try to avoid step number 2 ni. Patent litigation is the last resort. Try to settle out of courtnya dulu lah. Kalau kita letak proper solution, for let's say we ask for 1 million, dia kata dia tak mau lah, tak layan 1 million too expensive, and then we nego lah. How much you want to buy, how much you want to license, until we get the right amount, and then we settle nicely. Okay, this one example patent infringement yang berlaku lah, yang lawan dekat mahkamah. Bokita, I think the fashion punya people tahulah ini jenama, ada kedai pun dekat sini, kat office saya dekat atas Beranjaya ni ada satu branch from Lebanon, tapi dia file in Malaysia. And then they sue one company, Hayat Hijab. Dua-dua ada sekali, ada lagi sekarang, dua-dua famous. Katanya meniru so on, dia menang, lawan. Undisclosed amount lah, dia punya ganti rugi undisclosed amount. Ada sometimes IP case dia disclose. Contohnya macam Faiza yang beras tu, dia lawan dengan Faiz, Faiza dan Faiz actually family related juga kan. 4.2 million I think dia punya settlement. Itu trademark related lah, not patent related. Itu trademark and copyright, design. This one for patent undisclosed amount, usually not less than 6 figures lah dia minta. Yang jual eksklusifnya shawl ni memang make money lah. Dan kan dia jual satu tudung pun 200-300 apa tu, jadi dia nak minta ganti rugi pun banyak lah. Selalu dia takkan cerita lah, maksud maybe usually kalau yang high profile ni, dia after first session kat court tu, and then second session dia kata tak usah cerita panjang, kita settle kat luar, and then kan, and then dia dapat, dia tak mau cerita panjang, okay, settle kat luar lah. Jadi reporter pun tak dapat lah. Kalau dalam mahkamah settle, akan sebut dalam mahkamah berapa settlement, jadi reporter dapat tahu lah berapa figure. Ini mungkin tak settle kat dalam mahkamah sampai habis kot. Ini satu contoh local patent yang invention about side mirror, ada signal. Sekarang kereta memang common, tapi in 1990s dulu memang tak ada lah. Jadi ada local inventor file a patent, ada signal pada side mirror. Dia dapat patent in 2003, date of publication and grant 30 September 2003. However, dia tak boleh take action against infringer. Kalau in my opinion, kalau dia minta satu kereta RM10 pun dah cukup makan tak habis. Dia local inventor ni. Kenapa dia tak boleh take action? Sebab patent dia lapse. Dia tak bayar annual renewal. Dia tak bayar maintenance fee. Dia lost the rights. In 2010 baru dia ada kontak ni lah, dia punya kenalan dia, kontak saya, tanya opinion. Saya check balik lah sistem, patent dah lapse. 7 tahun dah lapse, baru dia nak take action. Rugilah, kalau tidak boleh take action against most car manufacturer yang jual kat Malaysia. Dalam Malaysia pun dah cukup lah, makan tak habis dah ni. Setahun Malaysia jual berapa ratus ribu kereta, tak tahu lah, boleh tengok data dekat AAM, Automobile Association Malaysia. Tengok model mana yang jual ada side mirror, ada signal, and then boleh claim lah daripada manufacturer tu. Because you have the
Radhi,
patent.
tumpang tanya sebab berminat dengan ini. This one actually dia apa, industri ke, researcher university ke, apa?
Dia private inventor, dia perseorangan.
Macam freelance lah. Dia patent kan?
Perseorangan yang inventor, dia dah patent. Katalah tengok daripada patent owner dia tak ada pun nama company or whatever kan. Macam banyak pasal private inventor ni, inventor perseorangan ni, yang personal inventor ni, dia memang ada banyak di Malaysia lah yang file sendiri invention. Sometimes memang bagus lah. Contoh example yang ni, tu 1990s ni memang idea dia come out memang bagus lah, dapat patent. Tapi unfortunately itulah, dia tak dapat take action because tak bayar renewal. Maybe agent dia pun tak advise ke, ataupun agent minta duit, dia ingat agent nak minta duit, dia tak bayar, something like that. Kan? Jadi dia pun buat tak tahu, dia ingat dapat CJ dah cukup, actually kena bayar annual renewal lah. Up till 20 tahun from filing date, 20 years from filing date. Ini rugilah, ini very... Okay, ada question, how much is annual fee? Okay, annual fee starts from the year after you get patent granted. For example, if you get the patent granted 2003, you start paying the annual fee in 2004, starting from RM290 for the second year. The third year is $360, and it keep increasing until the 20th year. In this case, the inventor only need to pay until 2016, which is the 13 years. 13 years, not 20 years. 13 years only. Maybe around 1,000 plus lah. It keep increasing every year. Because we assume you make money on the patent. Patent is a money-making machine lah, if the right channel. Okay, another one. This is self-commercialization from pertubuhan peladang. Ground leveler pasang kat belakang traktor ni untuk for the kebun or paddy field lah, so paddy. They also made and sell over 4 million plus sales lah. That was in 2018 lah, lama tak jumpa. Dia punya inventor datang pejabat, sembang-sembang, dia cakap lah 4 million, now maybe lebih lah. Dan juga plus dia ada patent dispute. Yang ni tak masuk, saya cuba cari kes dia. Dia kata dia lawan court case. Ada satu infringer dekat Kuala Selangor. Kuala Selangor kan banyak paddy field lah, sawah padi. Ada satu infringer yang buat the same invention, dia lawan menang. Saya cuba cari court case, dia tak jumpa lah. Dia punya tu tumpang peladan ni. Tapi dia kata dia menang adalah dapat composition, dia tak cerita lah berapa, itu rahsia lah kot. Berapa banyak dia dapat. Tapi sales dia cerita up to 2018 tu 4 million lah. Dia juga buat dan jual lah. Self-commercialization. Tapi dapat ke pertubuhan peladang. Pertubuhan peladang is the owner. Radhi is the co-owner. Actually, in this case, the owner, the cost all bear by the pertubuhan peladang. and then they amend lah, the owner is not actually tumpang nama aja. Kata buang lah. Actually dia tumpang saja. Patutnya tak perlu masuk lah dia punya as owner, and then they amend lah. Okay. Any question? Any further questions? That's all. And about the pattern.
Daripada ni ada soalan daripada chat Cik Radhi. Assalamualaikum Cik Radhi, adakah kita perlu risau untuk prior arts yang tak accessible macam Chinese documents or other language from other territory?
Okay, before memang ada concern on that lah. But now tak perlu risau sangat sebab macam I mentioned before, Google pattern dia ada Chinese document, Chinese pattern. Dia ada Google Translate dah semakin bagus sekarang. Before macam I kerja 2006, 2008 dulu tak boleh pakai Google Translate ni, memang tak faham pun dia punya translation. Now understandable dia punya translation, you can view full document lah. Apa nama pattern or utility innovation from China or ataupun Korea or Japan, it all machine translation but understandable. It's better now the translation. Cuma yang tak ada tu mungkin apa nama dalam language yang tak ada dalam Google pattern lah, Russian pattern whatever. Kalau dia punya abstract ada dalam database yang lain, boleh tengok English translation for the abstract, but the whole content is not accessible for now lah. Ada machine translation tapi okey lah, boleh tengok lah.
Cik Radhi, kami di pihak CIC USM, memang kami sekarang ni gerak kerja kami memang aggressively lah. We would like to encourage all researcher daripada semua kampus kami untuk melakukan pattern lah, macam sebab we have a lot of invention lah. Masing-masing keluar research, tetapi sayangnya sebab awareness lah, I can say awareness. Thank you Cik Radhi datang sini cakap all the things need be protected, something wonderful lah. So kami harap kita boleh, mungkin lepas ni ada lagi satu sesi yang betul-betul untuk menulis. Ni ada some kind like macam Prof. Semalam maklumkan lah, ini adalah introduction. Okay, soalan-soalan lain?
Ada ke?
Minta maaf Prof and tinggi. Bolehkah saya tanya satu soalan? Saya tanya yang berkaitan dengan CIC dan MyIPO ni lah kan? Hello?
Ya, kami dengar.
Hello. Ya. Prof, kita katakan kalau kita sekarang ni kita nak apply satu pattern, tapi katakan kita itu budget tak cukup lah. Yang itu USM dia ada support kami ke?
So far the step adalah kita akan datang ke CIC, kita isi IDF form, kemudian memang kita akan schedulekan untuk datang ke dalam USM punya komiti IPMC. Kemudian di situ kita akan bawa untuk dimajukan untuk proses ni lah, penajaan untuk proses. Right now apa kami punya inisiatif, sebab sebelum ni semua macam Cik Radhi katakan, kita guna pattern agent. So right now we try to move kita
the IPMC, we will try our luck. You try your luck, that's all. Pardon?
Tapi kalau tak boleh, kalau susah sangat physical, kita buat secara
Prof.
Maybe we will do much earlier. By 25th, we will do the IPMC besar.
Okay. So proses malam kita tekan dia ni. Okay, di CIC apabila kami dapat calling daripada researcher, okay nak pattern kan, we will ask you to isi borang IDF, kemudian kita akan majukan di pihak atasan. So ada 2 layer. So once kita dah check pattern agent, memang proof that you are novel, inventive dan industrial practical seperti Encik Radhi maklumkan, kemudian barulah kita majukan ke second stage. So kemudian ada satu lagi second stage, itu menggunakan sistem pattern yang Cik Radhi katakan pattern agent cost tinggi. Tetapi right now seperti Cik Radhi kata, why we need to have pattern on board, pattern agent on board, sedangkan kita boleh terus ke MyIPO. Inilah gerakan yang kita tengah buat. So ini adalah awareness. Jadi untuk menjawab soalan Dr. atau Prof tadi adalah memang CIC akan membantu untuk pattern kan, sebab we are encouraging all of us untuk pattern right now.
Okay, thank you so much. Okay.
Mungkin Cik Radhi boleh tambah sedikit apa yang saya katakan in term of cost tu lah. Sebab right now apabila MyIPO dealing hanya 1,000 lebih saja. Itu yang mungkin kunci utama Cik Radhi boleh ketengahkan. Oh, mikrofon Cik Radhi, mikrofon.
Sorry. Untuk internal proses memang masing-masing punya prosedur lah. Whether CIC, USM memang ada dia punya SOP lah untuk patent filing, untuk patent selection before go through filing. Prior memang guna agent, memang yang tadi I mention agent memang costly, but if you can prepare the document, the patent spec itself, and memang dapat jimat banyak lah. Maybe dalam kes ni mungkin ada kelonggaran ataupun SOP baru daripada pihak CIC. I'm not sure lah, gantung CIC akan tentukan kalau ada researcher yang boleh buat dokumen sendiri and go through filing. Depends lah. Ada what normally university akan ataupun innovation office akan file in group, innovation office yang akan tanggung fee. But there are some university yang pay and claim. Tak tahu lah, itu masing-masing universiti lah. Ada universiti yang pay and claim. Okay, dia kata okay, you prepare the document, you pay the filing fee yang minimum tu, yang 300 sebelum ni 370, sekarang 390, and then you claim dengan innovation office. Sebab innovation office just tengok ada hantar yang official receipt daripada MyIPO, and then dia bayarlah. Sebab dia tak ada memang official fee certain amount saja, memang fixed amount. Dia tengok berapa banyak yang based on dia boleh bayar lah, based on dia punya budget. Tapi normally innovation office akan kumpul, tengok, and then file in group lah. Dia akan bayar pakai PO ataupun EP ya sekarang. Kan tak pakai PO sekarang. Saya not sure lah kalau jabatan kerajaan perolehan, tapi maybe pakai purchase order lah daripada universiti. Dia file in group paid by innovation office. Depends on the procedure ataupun masing-masing punya polisi lah.
Suasana di USM sekarang ni kita nak memastikan pattern semakin meningkat sebab we can see the trend. Researcher macam takut untuk melakukan patent disebabkan rejection yang tinggi due to because as kita perjelaskan tadi, apabila guna agent memang costing. Tadi kalau tengok slide yang pertama Cik Radhi pun about 10,000 to 15,000. So menjadi sedikit selektif di pihak universiti untuk membayar. Kemudian ada setiap tahun lagi kita kena renewal. So coming this approach kali ni, kami cuba pastikan semua researcher miliki keupayaan macam Encik Radhi kata, okay, kita akan buat seminar demi seminar, guide bersama, dan you all akan coming kepada kita punya seminar, and then kita akan menulis sama, dan lepas tu kita keep blasting kepada MyIPO untuk dapatkan patent bersama lah ramai-ramai. So this is our direction right now, Cik Radhi dan all audience.
Berkenaan tadi ada Cik Mohd ada sebut berkenaan rejection, patent rejection kan. Patent attorney ataupun patent agent ni pun kalau dia buat prepare the documents, dia tak berani bagi guarantee boleh lepas lah. Normally usually lah, ini taktik ni kadang-kadang memang ada objection tapi good for their business lah, sebab menjawab tu ada di charge extra additional kan. Filing is for example 10K, and then preparing the objection punya argument tu pula maybe about 2 or 3K at least lagi. Itu separate payment lah. Itu after 2 or 3 years bila dapat yang first office action. Takkan memang masuk you submit pun tak boleh bagi garanti. Boleh nak buat you dapat patent claim. Claim number 1 you buat 1 page atau 2 page. Very narrow. Masuk numerical value. Memang you dapat patent claim. Takkan ada boleh dah sekali masuk clear cut case. Kita panggil tak ada bantahan, tapi your punya protection is very small. No value lah you punya patent. Kalau boleh kita nak yang balance lah. You dapat the best scope of protection dengan dia punya within dia punya yang boleh dibolehkan lah. Soalan
Okey, ada soalan lain ke?
Ada, saya rasa ada yang annual fee tadi Cik Mohd ada sebut, memang patent owner akan bayar. USM lah biasanya akan bayar annual fee. Yes, okay. And then unless kalau you dah jual patent tu lah, kalau you dah macam tadi you assign ataupun dalam you punya licensing agreement apa yang eksklusif for you mention kata okay yang industri yang license tu akan bayar annual fee. For example, you tak syarat, USM kata USM tak bayar, you ni lah, mungkin dia potong sikit dia punya duit royalty or whatever lah, boleh juga kalau yang tu. Tapi normally patent owner yang akan bayar lah. In this case, USM. Okay, satu lagi question ni apa ni? Effect of joint ownership. Adakah joint ownership boleh separately commercial? Okay, joint ownership by default, kalau ada macam tadi apa nama, saya bagi example yang pertubuhan peladang kan, ada satu mardi, ada satu pertubuhan peladang. Dalam patent, bila you submit the application, ada more than one ownership. For example, ada 2 owner, we consider it equal rights. It's not 50-50, it's 100-100. Masing-masing boleh sendiri separate punya apa nama commercialize masing-masing. Unless ada separate agreement yang bind the two parties. Bila you nak joint ownership tu, you kena ada separate agreement between the parties, what kind of rights. Kalau the other party nak commercialize, kena minta consent the other party. For example, USM dengan industri. The industry must ask for consent lah dengan USM. Usually memang industri tu memang nak commercialize lah, no problem lah. Kita ada bagi rights. Tapi kalau tadi kalau university, 2 university for example lah, tadi dengan industri memang dia nak commercialize. Kalau 2 university, the other university nak commercialize. The other yang university satu lagi pun kena tahulah dia nak commercialize. Dia tak boleh commercialize diam-diam. Sebab apa nama, ada agreement yang bind the two parties lah. Itu that's why bila ada more than one owner ni kena careful lah, yang tu innovation office maybe experience on that.
Yes. Macam kes-kes di USM sendiri pun macam di pihak R&I lah, Research and Innovation di bawah Datuk Rahman, kita boleh kata all finding yang keluar dari USM funded by daripada grant kita semua. So we try to secure whatever finding yang berjaya lah. Sebab tu unit inovasi kita akan cuba membantu give a best solution lah to win-win situation inventor dan industri and USM sendirilah. So sebab tu kalau ada any we can't say pukul rata sebab case by case, kita ada banyak jenis case, ada yang bagi duit tiba-tiba withdraw, ada yang duit bersama, so pelbagai case. Itu memang kena datang ke CIC, kita tengok case by case lah. Cik Radhi, ada soalan lagi di sini. Okay, Assalamualaikum. What about patent attorneys yang ada email mengiklankan servis untuk mengisi dan mendapatkan patent international? Bolehkah ia dipercayai? Microphone. Okay.
Sorry, lupa. Okay, like I mentioned before, there's no international patent, but there is international patent application. Tadi kata patent adalah territorial, patent rights is territorial, tapi ada satu konsep dipanggil PCT, Patent Cooperation Treaty, dia international filing, meaning that you file internationally through apa nama local IP office juga. Contoh you nak file tu, you file through MyIPO tapi PCT punya filing, you dapat international filing. WO, dia start publication dia WO, search dia punya search report akan dikeluarkan oleh International Search Authority Office yang dipilih oleh applicant. Yang Malaysia recognize ada 5 saja, European, Korean, Japanese, Australian. Apa dia kata lagi, dah tu lupa. Yang 4 tu ingatlah, mungkin ada satu lagi China ke, yang baru ke tak yang ni. Yang tu yang di-recognize. Dan setiap fee berbeza lah, setiap ISA tu, International Search Authority tu berbeza. Sebenarnya ISA banyak, Singapura pun dah jadi ISA tapi kita tak recognize dia lah. Tak pilih dia lagi. Ramai yang jadi ISA, ada Egypt, India, China asalnya baru kot dia pun dah dapat ISA, ramai dah ISA. Sebab ISA ni buat bisnes lah. International application only, not international patent. International application, and then after that you nak masuk dapatkan, you masuk apa nama mana negara mana yang you nak dapatkan protection lah. Jimat sikit lah, ada jimat untuk filing, tak perlu go individual country untuk filing, you just masuk satu filing, international filing, and then bila nak dapat patent rights baru go individual country yang nak dapatkan protection.
Okey, Cik Radhi, kita ada satu lagi soalan daripada Dr. Musfira. Kalau idea somehow ada from product claims but no process claims available yet, can it be patented under process claim?
Process or product?
Dia kata sekarang ni kalau ada idea untuk produk tapi but proses tu tak ada lagi. So adakah dia boleh dipatentkan di bawah proses claim?
Product.
Dia kata proses claim.
Process claim.
Dr. Musfira, mungkin Dr. Musfira boleh bertanya terus kepada Cik Radhi?
Ya, terima kasih Dr. Muaz. Ya, Encik Radhi. Because I think I heard that process claim is easier than product claim kan. So because kalau kata nak consider everything, for prior arts kan, kita risau juga boleh ke anything that is not expel ataupun not described in the product claim, but kita boleh agak as a a person expert of the field, they know kan apa tu. So boleh ke kalau kata if it's not stated or in the claims, in the product claims, but it's from products lah, not the process, boleh ke kita patent it as a process? Atau kena tweak or
okay, ada actually okay. Let's say doktor nak make the product may be well known, but a new process. You try to claim the process. In this usually dalam patent claim, normally orang claim product dulu and then claim process to make the product. But if the product itself is already known ataupun dah memang dah ada, cuma you create a new process, a new method to manufacture the product, you can claim product by process claim. Meaning that you claim the process first and then the product, the well-known product maybe, made by using the claim process. Is it clear? Is it the same as your question?
Okay, thank you so much Encik Radhi.
Saya nak try to create satu suasana baru juga. Okey, macam lanjutan Dr. Musfira. Okey, Dr. Musfira buat satu benda, contoh kemudian dia nak bubuh catalyst, mungkin catalyst to accelerate daripada 4 jam 2 jam. But dia berdasarkan teori, yes, it's happen, tapi dia tak buat lagi eksperimen tu. Jadi bagaimana? This is a conceptual idea.
Okay, boleh. Sebab patent is protecting the idea. It's not protecting the product or process yang ni. But the process yang you try to claim still in idea stage is plausible, is doable. Meaning that you're using the known process, maybe some little tweak there here and there, maybe variation of catalyst, something like that. Before using different catalyst, now using a new catalyst, yes. But the process might be similar, maybe not exactly the same, but similar to the known process. It's a new process. The process is considered novel if there's it's not anticipated by the prior art. 100% anticipated, it's not 100% anticipated by prior art, then it's a novel process, although it's still in idea stage. Kalau tak mau proceed, boleh file patent dulu. Ini banyak berlaku di industri. Dia tak, sometimes bila dalam R&D, dia tak sempat siap R&D tu, maybe takes 3 or 4 years, baru
tapi ada idea dah.
Dia dah dapat, dia dah envision dia dia nak dapat produk macam mana, proses macam mana, dia dah file patent dulu. Jadi bila dia dapat result tu, tak lari jauh dengan patent. Sebab patent kan very general, ada range. Result tu within the range, dia kata, that's it, kita punya patent dah, patent scope dah cover sekali yang kita punya produk yang dah dapat kemudian, walaupun dia file patent dahulu. Itu yang berlaku lah. Banyak berlaku di industri yang dia nak tunggu siap tu, lama lah, takes time, and then ada risiko dia punya R&D punya product leak tu, dia punya kompetitor kan, dia punya spy lah apalah kan, pancing dia punya pekerja lah. Itulah berlaku kat swasta, kat industri.
Saya rasakan ayat Cik Radhi ni very crucial to CIC and all USM staff, sebab right now kadang-kadang kita kerisauan, kita tak buat lagi. So having this contoh memang clearly every idea just coming CIC, isi borang dan kita buat patent bersama terus. I can see from that.
Pattern is protecting the idea, tapi tu kena satisfy the novelty search tu. Yang tadi saya buat kan, idea creation and then pre-art search, pre-art analysis before finding kan. Until during that process you buat novelty search. Lepas tu you dah satisfy novelty search, you dah envision what kind of end result nak dapat, you dah buat novelty search, tak okay, satisfy, and then you nak proceed to R&D atau filing dulu, up to you lah. Normally usually kat universiti dia akan proceed dengan R&D atau proof of concept dulu apa semua. Betul-betul dapat result baru nak file patent. Normally like that lah. Tapi selalu terjaga lah dia punya trade secret all their skills stay in the lab lah, tak keluar kan. Issue lah. Cuma kalau tu lah, kalau sometimes kalau selalu kalau melibatkan student PhD or master student ni takes time juga, jadi sempat siap sebelum nak file patent. Kadang-kadang kalau dia keluar pun dia tak terlibat dengan industri tu, jadi tak jadi isu lah. Bila dia keluar bekerja tu dia tak dia cuma bawa knowledge, cuma dia tak apply the knowledge kat industri yang betul-betul dengan research. Maybe the other thing memang dia apply lah yang other knowledge, tapi yang berkenaan research tu dia tak rahsia tak terdedah lah, rahsia research. Kalau perlu NDA lah. Itu kalau perlu. Kalau rasa tak perlulah. Dia cuma biarlah, tak ada masalah.
Cik Radhi, kita ada satu lagi soalan daripada Dr. Nurul Hasanah. Okay, if we have one patented drug to treat A disease, but we repurpose the drug to treat B and C disease, can we patent the application of the drug to treat disease B and C? Kita ada satu patent A, kemudian dia ada lanjutan berjaya patent B and C. So patent B and C pula.
Of course, it will become use claim. Like I mentioned before, use claim. First initial intended application is for A, but later on you found out that it can also be used for B and C. You just file a use claim for B and C. For the same product, just use claim. Already dah bagi tadi ada example use claim. Dia mungkin dah ada produk tu, cuma dia nak claim for use claim. So you get the use claim for A, B and C lah. But not limited. If somebody else found out, dah jumpa dulu, dia akan file dulu lah. Product is still yours. Product is yours for application A. But for the B and C, maybe kalau somebody else jumpa dulu, dia akan claim untuk use untuk B and C lah. You still make money from the product lah. Dia cuma dapat, okay, kalau tiba-tiba dia dapat tahu ada somebody else guna untuk dia punya B punya application, dia try to claim from the party lah yang guna. Dia takkan claim daripada product owner, sebab product owner memang tak boleh kacau. Cuma yang pengguna tu, yang guna dia punya application, industri ke for example, individual dia selalu tak kacau lah, dia nak minta duit pun payah lah individual lah. Kalau industri ke kerajaan ke yang guna application tu, dia boleh saman lah kerajaan ke agensi kerajaan ke mana for the second application tu, untuk use claim lah.
Ada lanjutan tu, Dr. Hasanah tulis sini, but if initial patent is not from me, still can patent.
Yes. Itu menjawab balik yang tadi saya kata lah. You found the second use, you file the second use for the produk orang lain, tak apa.
So nanti write up Cik Radhi, adakah write up tu bagaimana? Write up penulisan?
Write up is maybe you found out tu ada buat lab report kan, ada macam test lah, you test the product untuk second application tu. You test, ada lab report atau lab result lah. Lab result untuk you test in what condition, control condition, and then first condition, second condition, and then you claim the use of whatever product for apa-apa. And then use claim saja. You tak claim the product, you cuma claim the use for the second application. Tapi you ada dia punya supporting tu based on lab lab result yang you buat lah. Lab result guna the product, bukan lab result produce the product orang lain punya kan. You just maybe the dosage, different dosage. For example, untuk maybe first untuk A application guna dosage yang lain. Kalau ubat kan, kalau yang second dosage mungkin guna application lebih tinggi, dosage yang lebih tinggi ke dosage. Itulah yang, ataupun guna dengan something else, combination catalyst dengan kan, itulah.
So betulkan saya Cik Radhi kiranya macam ni, drugs yang researcher A, kita belilah, kiranya beli daripada contoh ambil market ke apa, kemudian kita try kat lab kita, kemudian kita test untuk analisis penyakit lain dan berjaya. So inilah yang Cik Radhi cuba katakan, kita menulis apa yang kita buat ujian seterusnya ni.
Ya, dia jadi macam yang saya bagi example tadi, Viagra lah. Kan? Initially untuk heart disease and then ada second untuk ED kan. Dia untuk second use. ED tu not sure. ED tu siapa claim? I'm not sure adakah ada same manufacturer of Viagra ataupun another company. Kena check balik dia punya patent claim lah.
Okay, semakin jelas.
Example lah, yang tu untuk ubat yang one example use lah.
Okay, mungkin ada apa-apa soalan lain daripada audiens? Okey, dalam masa yang sama, bagi mereka yang hadir, kita ada dua QR code. QR ni adalah satu untuk sijil kehadiran kalian semua, dan di sini minta disebaik semua audien menulis feedback untuk program ini, dan satu lagi adalah untuk QR code untuk MyCPD. Tadi sekretariat telah share di screen. Harap kalian dapat isi untuk MyCPD dan sijil. Prof Simela, Prof ada situ ke Prof?
Ya, Mas.
Prof ada anything sebab soalan tak ada, mungkin Prof boleh giving any end word.
Okay, thank you very much Mr. Razi. Kita belajar banyak. So harap kita boleh move on to hands-on lah lepas ni. And I rasa ramai juga partisipan dah tanya soalan. Kami pun ada belajar banyak daripada soalan-soalan ni. So hopefully soon to the participant as well. So ini as I said, this is just introductory. We will have hands-on to really mastermind the skills that was briefed today to you. Yeah, be it the search, patent search, be it how to draft. Kita dah tengok macam mana cara structure nak menulis pun tadi Mr. Razi ada share pada kita. So kita akan buat hands-on lepas ni. So mohonlah semua isi feedback form. Kami juga nak tahu sesiapa yang interested nak join for hands-on lah. Limited space, so first come first serve basis lah. So harap kita dapat lagi banyak sambutan lah Prof. Mr. Razi. So hands-on nanti, ya. Okay, with that, thank you very much. That's all from me, and thanks to all the participants and also CIC team, and terutamanya Mr. Razi, thanks to be with us for 2.5 hours, and it was a wonderful session. Thank you very much.
Prof jangan tutup lagi kamera Prof. I think our secretariat nak ambil gambar semua. Mereka akan close kita punya share ini, dan everyone boleh buka kamera for photo session. Syafiqah ke?
Lagi on the camera so that we can have a photo session. Terima kasih.
Syafiqah handle ke Syafiqah?
Ya saya.
Okay,
Syafiqah ambil gambar ya.
Alright. Okay, 1, 2, 3.
Okay, perhaps thumbs up untuk ni sesi ni Cik Radhi.
Okay, 1, 2, 3. Okay. Done.
Okay, thank you so much. Okay, daripada pihak CIC, kami bersyukur dengan kehadiran kalian semua. Audience really menunjukkan semangat dan bertanya-tanya soalan, which is good, because we are towards the directions, giving awareness, dan terima kasih sangat-sangat kepada Encik Radhi. Saya boleh katakan kita sedang bersama orang yang 2 dekad, 20 tahun di dalam MyIPO, Encik Radhi. Saya baca all your backgrounds. This is fantastic. Examiner, senior examiner. This is very orang bukan calang-calang ni. Okay, from us, thank you so much Encik Radhi. Semoga kita berjumpa lagi. Kalau tidak apa-apa, kita boleh bersurai. Terima kasih semua. Bye everyone.
Terima kasih.
Terima kasih Encik Radhi. Terima kasih Muaz.